Good evening, Advocate Hegde. Hope everything is good at your end.
Yeah, yeah.
First thing first, on behalf of the entire Caucus family, we would like to thank you for subletting your vital time to the probe. As you are already aware, Caucus is a 15-year-old non-partisan think tank and discussion forum of Hindu College. The Probe is a magazine started by scholars of the same back in 2020. Now I'd like to introduce you to both of us. I am Amaya, a junior editor with The Probe, and I'm joined by Shubh, another junior editor.
So, good evening, Advocate Hegde. We hope that you and your family are in good health. And once again, thank you for your time. We cannot reiterate it enough. For our readers, Advocate Hegde is a senior advocate of the Supreme Court with an esteemed career across all legal strata for well over 30 years and has also been the vanguard of socio-economic development in the country for just as long. As a reminder, the interview will focus on recognition of same-sex marriage with special emphasis on the Supreme case, as well as all the legal intricacies that come along with the same. We are sure your expertise and erudition will provide an in-depth view to all of our readers, and we hope to make this worth your while as well. Without further ado, shall we begin?
Yeah, yeah.
All right. So you have been, so we'll begin with the questions now. So you have been at the forefront of the legal terrain for well over 30 years, and it's safe to say society has evolved significantly since you began. In your experience, how do you think the legal landscape has matured to inculcate the LGBTQIA plus community, with prominent names like Advocate Guruswamy emerging alongside the infamous recommendation of Advocate Saurabh Kilpal for the judgeship of the Delhi High Court?
Well, the point is that both Menka and Saurabh are very good lawyers, and if any recognition comes their way, it is because they're good lawyers, not necessarily because of their sexual orientation. The fact is that uh, previously their sexual orientation may have been seen as a black mark or a reason not to promote them to judgeship or anything else that they could otherwise have been considered for. Uh, Now we are evolving as a society where even we are seeking diversity, and we are aware that people of the LGBTQ community also deserve to be recognized or to be participative in the whole process and in the, let's put it this way, in the sharing of power, in the sharing of responsibilities for running of this nation. Uh, Saurav's uh, uh, recommendation has still got stuck with the government, which is not uh, inclined to process it. The court, while reiterating his recommendation as a judge of the Delhi High Court, has also not proceeded further to put the government in a spot by issuing a contempt notice or anything of that kind. Uh, Speaking from some experience, I don't think that now Saurabh Kirpal uh, will probably make it be sworn in as a judge. However, he has not, unlike other cases where the governments have refused to appoint people who have been recommended by the collegium, and then thereafter the lawyer concerned has withdrawn his name. Saurav has not withdrawn his name, primarily because he wants to be a trailblazer in this regard. See to it that most of the objections that come against the community as such come in his case, so that it becomes much easier for the next case. So, in fact, I do think that Saurabh has done a significant service uh, to the cause of constitutional law itself, to the uh, question of diversity itself, by allowing his name to go forward, be not only being open about it, being discussed in so many forums, including this. These are all things which would have been probably unthinkable before the Nas Foundation judgment of the Delhi High Court, which is nearly about now, what, about 15 odd years or more. And I'm pretty proud to say that the Nas Foundation judgment just with was co-authored by a guru bhai of mine, Justice Murlidhar, and I went to this were juniors under the same senior. So, uh, despite the fact that the Supreme Court initially made a mistake in watering down, in overturning AP Shah and Justice Murlidhar's judgment in Nas Foundation, then it reversed itself in caution. So uh, this brings me to the point that as I think it was Martin Luther King who said that the arc of history is long, but it bends towards justice.
Thank you for that answer, sir. My next question would be regarding the understanding of the LGBTQIA plus community in the legal context and the union government's stand on the same. So, sir, the right wing union government has often reiterated that marriage is not confined to a private sphere, making it essentially a social institution. And intricate matters regarding social institutions must be left to the parliament. But there is a valid critique that the NDA's neglect to address the plight of the community in the past 5 years made the petitioners lose their faith in the union. How do you think the country should approach such a juncture?
Uh, See, it's very easy to take a view and say that this is all totally archaic and things like that. There are large portions of the community of people at large who probably have never met a gay person. In fact, uh, I think it was Justice Singhvi who, while hearing the Nas Foundation appeal, actually asked, "Do you know a gay person?" And so the fact that uh, gay people have now at least have had their sexuality decriminalized itself to a large extent was an act of progress as far as this large population is concerned. Now, to move from decriminalization to marriage or even civil unions, that still is a question where uh, should the courts take the lead or should we leave it to parliament? Now, courts, it is often said, do not make law. The the place for lawmaking is parliament, and the supposed basis for uh, parliamentary supremacy is, after all, that it gets elected by the people, whereas courts are unelected. So, should courts take the lead in what is seen by many as essentially a parliamentary function? Now, the answer to that, I think, to a certain extent, was given by Justice Joseph in the Election Commission judgment recently. He says it's a fallacy to think that courts do not make the law. Courts do interpret the law, and when they do interpret the law, they, to that extent, at least make it. Uh, Even the current constitution bench, which has reserved the judgment, has made it clear that it is not looking into personal laws, into the religion-based laws, because it does not want to go to that field. It is looking at the case of special marriage under the Special Marriages Act, whether it could be so interpreted in a manner to allow for a provision for gay marriages. Now, marriages or weddings can be a one-day event. Marriages are a lifetime and there are consequences. See, there are several consequences. Uh, Obviously, the spouse becomes a class one heir. So there are questions of inheritance. Now, if the spouses were, if it was a heterosexual couple which was childless, there are already there is already the Adoptions Act. Now, do you only interpret one section and allow for gay marriage, but not allow for the necessary consequences that would flow out of a marriage, including property, including uh, the possibility of having children, adopting children who would then go on to inherit, or also many other provisions of the law, which would all have to be interpreted if there was a declaration that you could have a marriage under the Special Marriages Act. I would not venture to make a prediction as to which way the Supreme Court would rule. But these are real practical problems. So there is often the question that you might interpret uh, any one section or any one act in a particular way. But if you have to uh, interpret it in a way that it has a consequence on several other acts of parliament, then where is the line to be drawn? Does the court not only interpret law, but does it actually legislate?
Right, sir. So you talked about the problem of adoption that the queer community might face. Upon that, I would like to ask you that the National Commission for Protection of Child Rights, a statutory body of the Union government, intervened in the case opposing the extension of the right to adopt for queer people. Such a limitation, if enforced, would be disastrous for queer couples as it would eliminate companionship and their lines of succession. So, do you think if a favorable judgment is given, such provisions should be instilled in the same? And if not, how should the legal structure actually tackle the same?
No. See, as far as the National Commission for Protection of Child Rights is concerned, it had its particular view. But I do think that the Chief Justice then actually told them, look, irrespective of the sexuality of the parents, uh, the children can be equally loved and equally at risk. The fact that that the parents are heterosexual is no guarantee against child abuse, or the fact that the parents are homosexual is is no reason to believe that they will abuse the child. So NCPR intervention was made for whatever political or other reasons that it had. But yes, the problem about uh, how once marriage is allowed, how would you define the family? How would how would succession rights be worked out? And also, in the case of a divorce, what is to happen? Who is to have custody? Now, in the case of heterosexual marriages, normally the mother is often given custody in the earlier years, and unless there is some specific reason why she is not given custody, only then is the father and the father side of the family looked at. Here, which of the two people in the marriage would you grant custody to, or does it all have to be done on a case to case basis? So these are many of the questions that will arise. One set of arguments is no, today you stick to the marriage question, Let us resolve that question. As and when further questions arise, no doubt you will have the wisdom to rule on that, and the country will accept that as the law in those cases.
So the Supreme Court in 2017 held that the right to individual privacy is an intrinsic and fundamental right under the Constitution. But the BJP's constant rejection to accept the equivalence of rights of the LGBTQIA plus community directly comes in conflict with the judgment. So, do you think the union is overreaching and even berating the court's position as the highest law of the land by describing same sex marriage as a public issue?
Well, I would not confine the BJP's understanding of individual rights only to the queer community. Uh, the the BJP comes from a cultural space which tends to value responsibilities more than individual rights. The very idea that individuals have rights comes to us from the Rights of Man, which, when translated into Marathi, were read by Mahatma Phule, and from Phule's writings went down onto Ambedkar and have worked its way into the Constitution. The the otherwise, uh, culturally, people did not seem to have too many rights. They had all the responsibilities. Karmanya vadikaraste. So that, that being the situation, I do think that the BJP comes from a space where it does not uh, give too much of an emphasis to individual rights. And the rights of minorities, whether on religion, whether based on sexual orientation, even come further down the down its list of priorities.
So thank you so far. So now there's this one very overarching thing which I've seen so far in your answers, which are your tendencies to quote precedent. And as someone who's very much into the legal intricacies, I really enjoy that. So while I'm pretty glad you're doing so, I have a few questions regarding the same. And first of all, I would like to begin with there's been a lot of talk about the Special Marriage Act. And so the Special Marriage Act has had a lot of limelight during the arguments. As an esteemed legal luminary, can you explain the limitations of the same with relation to the case, and how big of an impact can the petitioner's plea to reframe the term spouse as gender neutral really make?
See, the Special Marriage Act itself has a long history, and it has impacted India's constitutional history as well. The Special Marriage Act came at a point of time in British rule when there were laws which defined how a Hindu marriage was to happen, how a Muslim marriage was conducted, and all that. Now, what would happen if people wanted to get into a marriage without necessarily having a religious connotation? And that's how the Special Marriages Act came about. And in the beginning, it had you needed to declare that you did not really believe in any religion and you wanted to get married under the Special Marriages Act. Now, the way this impacted our political history was when Muhammad Ali Jinnah uh, was being pursued for marriage by Rati Petit, who was a Parsi. And the Petit family was against the marriage. They even went to court against Jinnah, where Rati Petit comes to the witness box and says, "No, Mr. Jinnah is not pursuing me. I am pursuing him." So, uh, if if they were to get married under the Special Marriages Act, there would have to be a declaration that both people did not believe in a religion. That would have been fatal to Mr. Jinnah's political ambitions in the Muslim League. And that's how Rati Jinnah converted to Islam, married him. But then thereafter, I don't think lived a particularly Islamic life, and her daughter was brought up by her Parsi grandparents and married a Parsi, and from where you have Nasliwadi of the Bombay dyeing family emerge. So these ideas of uh, different kinds of people being allowed to marry and their rights and obligations being codified was what defined the Special Marriages Act. So now has comes the question whether the term spouse could be rendered gender neutral, and that instead of a man and a woman marrying, two persons could marry. Uh, well, let's see. An interpretation has been suggested to the court. Whether the court buys it or whether the court says, no, what you are asking is really for Parliament to do. Uh, we cannot give you a declaration that your relationship can be termed a marriage, but we can some other kind of relief may or may not be given. These questions are still at large, so it would be uh, unwise on my part to make a prediction as to which way the judgments will go, and whether the term spouse can be read in a gender neutral manner. However, uh, what also happens is that cases may be uh, won or lost in a court of law, but can equally well have an opposite effect in the general public, in the court of public opinion. The very fact that these questions are now uh, being raised and are reaching the people at large is an enormous social advance. I do think that the fact that all these proceedings have come out on the net, that people have watched the arguments in court, uh, and snippets of them have been circulating on WhatsApp and other forwards, have all gone to make people aware that there are these possibilities, and maybe it's not that bad an idea or that radical an idea. That itself is great progress.
Yeah, so I think no one else could have summed it up better. And some of the points you just raised up really segue straight into what I really did want to ask after this. So I have two questions for you which directly relate to what you just said. So the first of them was the concept of gender has become a hotly debated juncture. In your opinion, how important should abstract concepts be to the superior judgment? And second, I really liked how you emphasized that there are people watching the constitutional benches through the Supreme Court's portal and how it's being shared in snippets. So one favorite snippet of mine was something that really initiated the conversation. Was on day one of the hearing, Honorable Chief Justice of India stated that since the Nafte judgment, tolerance towards the queer community within the country has increased. Would you agree with the same? And do you think a favorable judgment would make people forget all their objections to gay marriage 5, 10, or 20 years down the line?
See, uh, when a judgment is delivered by the court, irrespective of whether we like it or not, we all have to follow it. That is, unless Parliament steps in and changes the legislative basis of that judgment. So, while all of us who are of the progressive variety wish that the Supreme Court were to come out with a judgment and that the public at large would live by it, those of us who have been long enough in the law also know of the other possibility where the court gives a judgment but the people do not accept it, or Parliament then takes away its legislative basis. So uh, the thing is that the questions of this nature have been uh, in India have progressed much faster than they have progressed elsewhere. I mean, as far as the legal process, from decriminalization to the question of gay marriage, we're about less than a decade. Whereas if you see the position abroad, it took a long time in the US from decriminalization to the attacks on people like Harvey Milk and the rest in San Francisco, to the AIDS epidemic, till Obergefell came uh, in and around 2010. So a process which took much longer in a more developed society and in a more literate society is being yeah, I won't say fast tracked, but but has seen some expedition. We the courts do not have uh, untested a tested barometer of public opinion, and nor do courts go by public opinion. They, it's not only in this field, in any field. If the law is stretched too fast, too far out, then there is a tendency for it to break, or for it to be replaced by someone else. But at the same time, inaction is not a solution. If people had been inactive for want of legislative changes, eh, uh, maybe we still would have had sati going on in this country. Maybe still would have had so many other things like untouchability going on in this country. You must remember that after the constitution was drafted and came into force, Dr. Ambedkar wanted the Hindu Code Bill passed. And there was a lot of resistance at that point of time. There were even people who said that the Hindu Code Bill was being passed specifically so that Hindu women could have the right of divorce, and that would then benefit Nehru's daughter, Indira Gandhi, who did not necessarily have a happy marriage at that point of time. So, all kinds of motives get attributed to this function of lawmaking. But men and women of law do not necessarily sit on their hands. They, you told me that I was fond of precedent, but often it is said that the law advances from precedent to precedent. You go on the basis of precedents and then try to stretch it a little bit further to make it a little bit easier for a lot more people.
That was very well uh, articulated. So I think Amayal's got a few more questions for you now.
Yeah.
Uh, yeah, so, sir, you talked about how Parliament has the prerogative of overturning a judgment. So, my next question is built upon those lines. Uh, so, in an interview, sir, with Archduke Sudhir Chaudhary, erstwhile Law Minister Kiran Rijiju contended that five people cannot decide the direction of the country, and such topics can only be decided by an elected parliament. Many critics have suggested that this has a shade of the Shah Bano case. Would you be in agreement with the same, or is it a hyperbole in your opinion?
Well, the former law minister, bless his soul, uh, uh, should uh, should then explain how five people sitting in the same Supreme Court changed the face uh, of the Ram Mandir issue. The same five people also struck down triple talaq. So it can't be that when you get judgments from five people, they are the law of the land. And when you get judgments that you do not like, then they cannot make the law. I do think Mr. Rijiju probably need to apply himself uh, better to the law. He is a politician and has a lot with a law degree. Has not probably worked that much in the courts. I would leave it at that. If five people are good enough to build the Ram Mandir, five people are good enough to strike down triple talaq, then you must also listen to the five people. If they say that two people, uh, irrespective of their birth assigned genders, have the right to marry.
Right. Quite an interesting answer, sir. So, where would you put the same-sex marriage topic on such a limited field of maneuverability?
Where would I put it in? I'm sorry,
Uh,
your voice cracked.
yeah, I will repeat myself. Where would you put the same-sex marriage topic on such a limited field of maneuverability?
No, the same. See, this is a judgment of the court uh, on a question based on the Special Marriages Act as to whether same-sex marriages can be registered or not. I I would certainly place the judgment I mean the judgment when it comes will be a historic judgment, even if it declines relief, because it will be the judiciary examining the law as it currently stands and saying that we, we have tried our best to interpret it in a manner consistent with giving uh, uh, people of the LGBTQ community a right to marry, but but the answer doesn't lie in the courts. The answer lies in Parliament. I mean, this was the same kind of answer they could have even given in respect of triple talaq. So I would let's not go ahead of ourselves and predict what the judgment will be. Irrespective of which way the judgment comes, it will be historic.
So just building upon the same, the I would like you to predict just a bit more because I feel like this is something which has been. Uh, I had really seen a lot of the hearings, and one of the ones I remember very vividly was Dr. Singhvi and Advocate Guruswami's heated argument, as it has been framed, versus Solicitor General Tushar Mehta, and the crux of the argument has been that five people recognizing would completely break down the legal machinery. So, would you consider the same? Would recognition result in the breakdown of the legal machinery in the foreseeable future, and or how could such a situation be avoided? Because that is really much the crux of the respondents' argument.
Well, the respondent's argument is that courts should not decide. It is for Parliament to decide, and we assert parliamentary supremacy. So that's a perfectly legal argument. Uh, the this five people and five people can't do it. That I don't think is necessarily a good argument, because these are the only five people who can or cannot do it. In that sense, all that these five people are doing is saying, "Look, Parliament, you've made this law. This law can also be interpreted to mean this, and consequently, these people can get relief." I the question, and I mean, quite apart from the arguments of the lawyers, I you must pay more attention to the questions of the judges themselves. And Justice Butt had some very probing questions. right through. So it we we cannot necessarily just predict the result based on what the lawyers have argued, what the lawyers have said, what we have liked in the arguments. Often the task of writing judgments is when the mind is finally made up. Uh, in the U.S. Supreme Court, when they were during arguments, Chief Justice Roberts was entirely against Obamacare, but when he came, and he, in fact, in judicial conference thereafter, he was he revealed a preliminary vote to strike it down. But when he began writing the judgment, he realized that there was one way where it had to be upheld, and he changed his mind. That's how Obamacare got upheld. So uh, till till the last sentence is dictated, thought through, fought through, and the drafts are corrected, the judgment is still at large. All that we can say with some surety about that judgment is that it has to come before October, because October is when Justice Butt retires.
I think you've really summed up why we really like having experts on the probe, because insights like these are something a lot of us with no experience really do miss. And something like this is very vital to how all of us, and including me, really did open up a new point of view for me, something I might have overlooked in the past. So thank you very much for that. And now, building upon your experience, the next question is, the abstraction of family has been mentioned often enough, but what is not mentioned is how the youth of the country views the progression of the family. How do you think the court should take cognizance of the same to make sure that even the young have a right in deciding the foreseeable future, and we do not end up in another Nas and Naftage type situation where it took 9 years for the court to finally give a
Well,
judgment that way? Yeah,
there is no but. How do you define the young? May you can bet your life that many of the people on the bench themselves think of themselves as reasonably young, at least in thought.
yeah,
The second part, no, the second part is that I do think that the young of India have a very, very significant voice, and they are the ones who will ultimately be handling whatever result the courts give or the legislature gives. So, but the first thing is how do the young make their voices heard? There was no particular intervention in the court proceedings, and maybe if somebody had intervened, and if he or she had something substantial to say, they would probably have even been heard. The other part is, and this is where I'm going beyond the topic of just same-sex marriage. The best way that the young can be heard is just to and consolidate marriages that was done where people to get a job. What is ahead for us? What you want to see in the next 15, 20 years, that when we will be in the prime of our lives, that you have made provisions, or are you simply passing time and borrowing from the future? Courts do have their own. I mean, one of the ways that judges and senior advocates keep in touch with what the young are thinking is by talking to their younger associates and their juniors and all, and they are mm, uh, often seekers of wisdom from the young as well. Uh, it, Ram Jethmalani used to quote King Solomon. where he said that if you want to remain young, be with the young.
I
So,
think that
as far as I can see, the youth voice does come in, but comes in indirectly.
I really do agree, and I feel like the the resolution by 38 queer alliances from national law schools and other law schools really do come into play here. Of course, it didn't reach the Supreme Court bench, but I do think what you just said really does complement the same, and there should be more intervention on the same. Now, while I delve deeper into what you just said, I hand it over back to Ameya.
Um, okay, so my next question has a certain amount of a political hue in it. Uh, so, how would you define the union's hypocrisy that has usually been motivated by political mileage? As we have seen, the INC come out in favor of the Navtej judgment and support the Supreme petitioners, but when they were in power at the union at state levels, they were the opposers during both the 2009 as well as 2013 NAS hearings.
Well, who was it who said that politicians will do anything to get elected? They will even occasionally tell the truth. So it's like that. They often have a different view uh, of proceedings when they are in power, and they have a different view when they are out of power. Uh, in the U.S., the saying is that uh, a, a Democrat is a Republican who got arrested. A Republican is a Democrat who got mugged. So, like, it often happens to be a question of life experiences. And yes, political parties have their own ears to the ground. They say that look, we will echo what the voters want to hear. We will do anything to get elected. Quite apart from this, there have been there was a great hue and cry uh, when the Congress manifesto last time. They said that they wanted to get rid of the law of sedition. While they were in power, they never did anything. Though it was Pandit Nehru who said that the sooner we get rid of it, the better. And they sat over it for all those many years. And today we have the current government, which also railed against its misuse earlier, but now whose law commission says no, 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 we should still continue with the sedition law. So things look different to people in power, and when they lose power, that's when they rue all their missed opportunities to change the nature of the law.
Right. And I think the same happened when the farm laws protests were going on. The Congress was opposing the same farm laws which it had in its manifesto. So there's that. Another question along the same lines would be the union's now debunked stance that same sex marriage is an urban elitist idea received widespread condemnation. Would you consider the union out of touch with its citizens and agree that politicians only care about like minded subjects?
This argument of it's a minuscule minority was there even in the Nas Foundation judgment of the Supreme Court. So they, it doesn't matter whether it is a urban phenomenon or a rural phenomenon. At the end of the day, it's a human phenomenon. And if you cannot uh, reach out to the lost and the least of your citizens, then you are not necessarily doing your job, right? Uh, it, it's it doesn't matter whether you classify it as Eastern thought, Western thought, or anything. Uh, are there same-sex people in India who prefer same-sex commitments? Yes, there are. What are you going to do about them? Do they not have a right of marriage, or do they not have a right to have at least some uh, recognition of their relationships in a manner that they live their lives in as near a closer manner to what the others live. Say that they have the same rights in terms of inheritance of property, in terms of passing on the property to their loved ones, in terms of bringing up families. So, how do you provide uh, equal treatment for all, including for those who have some specific needs? Can you not reasonably accommodate your law and your society to provide for all?
Over to you, Shubh.
Right, so while we're on the topic of respondents and politicians, I have two more questions to follow up with you. In the written arguments before the oral hearings began, in the written arguments, the state argued that while all citizens have a right to an association, the state is not bound to recognize the same. Alongside the fact that not recognizing various forms of marriages, unions, or relationships between individuals and society is not unlawful either. In your violation, would you consider this, in your assessment, would you consider this a violation of Article 19?
See, uh, the right to association wi- was traditionally the right to form unions and mass associations, an association of two people to be recognized as marriage, or to be recognized with the same commitments that flow, equivalent commitments that flow from a marriage. Uh, would it come within the ambit of 19? That's an interesting line of argument. Uh, However, I think the basic value that the basic constitutional value is dignity, the dignity of the individual. That is what has been assured to us in the Constitution's preamble itself. And every person has the dignity, and the dignity that flows from a marriage and a commitment and a relationship uh, which is intended to have legal consequences, that should be available to everyone.
I totally do agree. And on the second one, while we're still on respondents' motion, the respondents have emphasized that the Indian family unit, which consists of a cis man and a cis woman as a husband and wife, and the children born to them, is a quintessential building block for the existence and continuance of the society. Would you agree with the sentiment? And do you think procreation is the major pillar upon which society stands? Or do you think eventually the value of procreation would fade away and this notion should be rejected by the Supreme Court?
I don't think the value of procreation has faded away, and to an extent that the Supreme Court needs to recognize its fading. Yes, procreation is an important component of marriage, but it's not the only component. Uh, See, in let's just take a very ordinary situation where somebody needs an emergency surgery. Now, the person who gives consent for that surgery is a loved one, or often a spouse. If there is no recognition as a spouse, then the person can't even give consent or be in the make any of those decisions. So, so this kind of recognition of support, of spousal support, uh, that is very important for yeah, for equalizing the field and to confer dignity upon every individual, irrespective of sexual orientation.
That is totally accurate, as I would put it. I feel like Amaya would have a few more questions before we end.
Yeah,
Done.
because I think there's somebody who wants to get in touch with me. Anyway,
Yes, just one question before I'm done with my part of the
yeah.
questions. There has been the rise of the term cultural Marxism within the conservative sphere on topics of recognition of the queer community. The designation has created a fresh negative outlook towards queer people. So, do you think it's bold to assume that legal protections would eradicate social stigma as pleaded by the petitioners?
See, this is what is it? This is name calling and lazy name calling at that. We are getting in all kinds of things, and particularly because social media, in one sense, unites the world, it also divides it into specific tribes, the wokes and the non-wokes, and so and whole kinds of George Soros ridden conspiracies and things like that. Uh, the basic instinct in name calling is to denigrate the other person or the other group of persons. To a it is hateful, and sometimes it can descend even to hate speech. Often the response to name calling on one side is name calling on the other. But I do think a better response is to just ignore and let your work do your talking for you. It would be, mm, let us hope that the Supreme Court judgment, when it comes, takes takes all these things beyond the realm of mere name calling. It restores dignity, which was lacking in the case of these relationships.
It's so one last question before we end. I hope you're fine with that. Yeah, this comes straight from your field and your experience. The union's constant reminders of its lack of tolerance towards the queer community have been documented. So, would you like to comment on whether the trauma for queer people looking to enter the legal world is worth it? We have seen the rise of prominent legal resources like Anish Gawande's Pink List. We have seen advocates like Rohin Bhatt and advocate Utkarsh Saxena fight the Supriyo case, and Guruswamy, I have already mentioned advocate Guruswamy and advocate Kirpal. So, where do you think is it? Would a favorable Supreme judgment encourage more legal scholars, or do you think if a judgment goes the other way, it would uh, lower the quality of legal scholars that are coming into the field?
Irrespective of which way the judgment goes, there now is greater engagement with the court. And just because things are tough, people do not stay away. The queer community has its struggles, but equally the women have had their struggles. The underrepresented Dalits have had their struggles. But, and if Ambedkar had said, "Oh, what do I do? I am a poor Mahar boy. My father was only a soldier under the British government." I, if he had sat on his hands, would we be able to stand up? Would Indian citizens be able to stand up? So everybody has a contribution to make. Everybody has a fight to fight, a path to walk. I do not think that anybody should be dissuaded by the fact that the path is difficult.